law. And the law is real clear that Mr. Miller really has no legal claim.
Okay, so, yep, let me just here's your memorandum. And you said the land contract's in here someplace too?
Yes, we sent that over, Judge.
Okay. Let's look if I can find it.
Prepay rent, 61 years,
We
thank you.
advised the court that Mr. Miller dropped off some tax returns to our office yesterday. We asked for his email and he said just mail it, so we overnighted some stuff to him.
You talking about who made the contract? Who has 61
Miller,
years
why
of
don't you
rent?
unmute as well there for
Ready
me,
to
just so
pay.
I got you on.
Your Honor, if I may?
Hold on just a minute. Let me just kind of see what I've got here.
Yes, sir.
Got the trust. Assignment of land. Seller's interest in land contract.
Okay, we on 1080. It's not looking real 1080-ish, but
Browser, looks like I've got, I bet you this is it. I was gonna say the only thing I don't have is the land contract, but I might have it here. I think this is it.
were they able to
Tax
find the land
documents.
contract?
I can have it sent over again, Judge.
Yeah, boy, you've been good enough to send everything else over here. I gotta be in here. What was it attached to? I've got an assignment of seller's interest in land contract. I do have that.
Yeah, the actual land contract, we managed to find that and we did send that over.
Okay.
Did they read through it?
If you want to, rather than me trying to, if you can just email that part of it over to me.
Yes, if you'll excuse me, I'll go have my,
Sure, and it's good. Just do it to Janet again. J. Dries. Yeah.
The original? I
I
don't think he said.
no, but I'm
He
having
didn't
him do
send it. Yeah, they try to pull the okie doke. Does it look like the sun? Is this the sun back here?
This is television session.
You know what, Mr. May? I just found it.
Oh, they did send it. My fault.
Yeah.
My fault.
Yeah. Yeah, you just found it. Never mind, Tammy, they found it.
Sorry. Yep.
All
Mr.
right.
Belzer, I did find it. It was underneath the other paperwork for some reason.
Okay, good.
I do have it. So, okay. All right, so I guess let's just start from square one again. We'll start completely over. I do have the documentation. Mr. Belzer, Mr. Miller, I kind of cut you off. What did you want to tell me before we start? Was there something before we start?
Your Honor, I would like to ask the court if I could move to dismiss this matter on the basis I was never provided a notice to quit. I have some support I would like to offer for my motion. A notice to quit is required in most circumstances with a few exceptions. One, after forcible entry. Your Honor, I came under color of title pursuant to the lease.
I don't
requiring
think we're up to that part yet. Let's just see how the land contract part goes in first.
He
You know,
must
they're
have read the
suggesting
land
they have a land
contract or something.
contract to the property. That's what they're saying.
Well, is there anywhere on there that there is a encumbrament on the property?
There's what?
A encumbrament on the land contract?
An encumbrament? Encumbrament? Is that what you're
Yeah.
talking about?
I think it
Yes,
said
sir.
encumbrament.
Yes, sir, Your Honor.
Well, we haven't got to that point yet. Let's just kind of go through, Mr. Belzer, let's just go through like we would a normal.
Mr. Miller not
hearing
playing.
again, because now that I got
He
all these
about his
documents,
business.
let's just do it, okay? Mr. Belzer, do you have a witness here? Why don't you go ahead and,
Okay, I'll have Mr. May, who was previously sworn.
okay, yep, we'll just, Mr. May, why don't you raise your right hand there? Do you
He
swear from the
definitely did.
testimony you're about to give me the truth?
I do.
Okay, Mr. Belzer, if you could just kind of lay all the facts out for me and we'll.
I wonder if
do
his
it.
attorney's gonna
State your
show
name
up
for the
this
record,
time. Though.
please.
Jack Douglas May.
And Mr. May, you caused you own this particular piece of property at one point in time personally, is that correct?
I've owned it since either through my corporation or
No,
myself.
my question is, you owned it personally at one point, or did who owned it first when you bought it?
Corporation, the
So
corporation
your
owned it.
corporation owned it, you subsequently transferred it to a trust that you have,
Yes, I did, Jay.
and it
He
came
taking
to
notes
pass
too.
that you did a land contract with your son Brian, is that correct?
Yeah, the corporation did the land contract and I assumed it.
The corporation did the land contract with Brian, is what you're saying,
Yes,
correct?
right.
And then subsequently, the corporation conveyed this property to your trust, and the trust now owns that deed to that property, correct?
Correct.
And on that land contract, we provided the court a copy of that. And that's the land contract that you entered into with your son Brian, correct?
Correct.
And he failed to make payments on that contract, is that correct?
Yeah, he's never
Oh,
made a
his son
payment,
did.
which
Damn.
I didn't enforce that.
But he
okay,
got-
yes. No,
Okay.
never
He
made a
got
payment.
144,000. Why he wasn't
subsequently-
paying?
In lieu of court proceedings, your son Brian signed a deed giving that property back to you, is that correct?
That's correct.
And at the current time, you have the deed to the property. The land contract has been extinguished by virtue of the last quitclaim deed from Brian, is that correct?
That's correct.
And your son Brian's here also to testify if need be, correct?
If they
Right.
evict him,
That's
I'm gonna
correct.
be sick.
And you had no dealings yourself with Mr. May or Mr. Miller. You didn't enter a contract with him. You didn't enter a landlord tenant arrangement with him, nothing, correct?
I had no dealings at all. No.
Judge, and that's a testimony I need from Mr. May, from Jack May. And the land contract is in fact with the court, as well as the deeds that show the transfers back.
Did you have, yep, and I've got the assignment, I assume what you're talking about, Mr. Belzer, is the assignment of the seller's interest in the land contract?
Yes, yes.
I do have that, and that's dated this, boy, 31st day of December 2005, is that right?
Right, that's when it went from the corporation to the trust, is that?
That's correct.
Yes.
Yeah. The
Okay.
end of the year.
Into the trust, so that's that date. So we got December 1st, 05, and then the land contract we had. In the land contract that was in effect, I'm sorry, you started, Mr. Belzer, with regard to the, actually, we probably should have these submitted as well, as long as we're doing this properly. Do you want, are you asking me
looks so
to review
confused
the
right
land
here.
contract, the assignment that we just discussed, and the quitclaim deed that was just testified to?
Yes, Judge, the land contract was dated July 27th of '06.
Okay,
And then the quitclaim deed that deeded it back after that forfeiture of the land contract is dated February of 15. No, is that right?
Yeah, that's correct.
Yeah.
I didn't deed it until later. I missed on doing that.
so I've got I guess, Mr. May, for my benefit, the land, all these documents, the land contract that you just testified to has your signature on it. Yeah, May Homes and Realty by Jack D. May, and that's your signature that's on that too, that's dated?
Yes.
Okay, and then on the quitclaim deed that's dated February 10th, 2015, that's also your signature, Jack D. May, quitclaim it over
Yes, it is, yes.
the trust? Okay.
I want to hear Mr. Miller. What he got to
And
say?
Judge, then, if I may, there's also
Sure.
the deed from Brian.
Who this? This is
know,
So this is a tenant, right? It's the case. We already watched part one. This is a tenant right here, Mr. Miller, against the house owner, which he doesn't really own the house because it's owned by a trust that he has. So what Mr. Miller did was he paid years in advance on his rent, right? He paid 61 years in advance in his rent to live in his spot. How he got the money, we don't know. You know what I'm saying? But he paid that much in advance. And now this guy's son right here is who rented it to him, right? 61 years, War. He could have bought a house. He definitely could have bought a house. But this is the guy's son is who rented it to him. The dad is like, I never let this happen. Like, what? Let's get him out of my crib. Like, I don't know why he doing here. My son was tripping. You know what I'm saying? So here we are.
Satisfaction of the land contract that's dated August 14th of 2024.
Oh, and I did see that too, August 14, 2020. Let's see that. There it is, I believe.
He definitely could have bought a house with that. Yeah, it's crazy. But he did it for his kids in the community, he said.
Those you just hold with me. It's August of 2024. Is that what I'm looking for?
Yes, Judge.
Where am I going to find that? Which I thought I saw it at
The
one
judge
point.
always
Is it
seems like
attached to
kinda
one of the
lost,
other
though.
ones, or what am I?
Yes, Judge, that was filed early on.
Okay. Oh, maybe it's in the file still then. Okay.
With the original complaint that
Can
was
that be his
attached,
son?
Judge.
Because he looks a little
Okay.
older.
Let me look back in the.
That could be his son, huh? Where your paperwork at or what's going on? I
Up
would
here it
be
is,
sick,
August 14,
Kyra.
2024. And it looks like that was recorded as well. So I do have that document as well. The quick claim to Jack D. May, trustee of the revocable trust. That's the one we're looking at.
Yes.
That was dated August 14th, 2024. Okay. Mr. Miller, any objection
go.
to any of these documents?
Your Honor, Michigan law,
Exhibits?
Bob,
Hold on. And any objection to these being admitted as exhibits?
no objection, Your Honor.
Okay, so we've got exhibit. Let's just do this in some kind of nice orderly
No
fashion. I can
objections.
figure it out. How about, for both of your sakes, exhibit 1, the land contract dated July 27, 2005 will be exhibit 1. Yeah, that'll work. That's admitted. Then we've got
He got a hole in his cup or something?
assignment of seller's interest. I'm just going down what's attached. Assignment of seller's interest in land contract to the trust. That's dated December 31st, 2005. That'll be exhibit 2. And that's admitted.
I just want to know, like, what did they do with the money that he paid?
And we've got the
Because if you paid me
Quitclaim
61
deed.
years in advance for anything, you could live in that motherfucker for as long as you want. I'm
From
good.
Mr. Jack D. May to the trust itself. That's dated February 10th, 2015. That'll be exhibit
He
3.
smoked it up.
Sorry. Exhibit 3, that's admitted.
Bree, appreciate the 12 months. What's good with it?
And then
Oh, I forgot I muted the
exhibit
alerts.
4, quick
My
claim
fault.
deed from Brian May to Jack D. May as trustee of the revocable trust.
I think he paid like a
That would
portion
be-
of it. War.
Exhibit 4. Exhibit 4, and that's admitted. Mr. Bowser, does that cover the,
I think he paid like
exhibits that we need right now? Is
140,000
that
or
right?
Yes,
something.
Your Honor. Yes.
okay, so those are admitted, and Mr. Belzer, I guess if we've got other testimony, do you have other testimony right now, Steph?
Well, not at this point. I mean, if
The
Mr.
judge
Miller
seems so
wants to raise
lost.
this $144,000 question, I have Mr. Brian May here to testify that
That is
never
the son.
happened.
Okay.
Um,
Okay, so Mr. Miller, are you gonna testify?
Your Honor, Michigan law 554.134 requires a notice to be served on a tenant. Proper notice is conditioned precedent to a summary proceedings action, Park Forest of Blackman versus Smith 112, Michigan. Park Forest held that the landlord's failure to comply with the notice requirements of the state deprived the district court of jurisdiction to hear the case. As a result, I am entitled to due process, which requires a proper notice to quit be served. And without proper notice, the court lacks jurisdiction and this case should be dismissed.
So the only thing that you're arguing, Mr. Miller, is that there's this lease agreement? Is that right?
Your Honor, I have a valid lease agreement with Brian May.
Okay, do you want to test it? But we're not even at that point yet. I've
He's
got
like, look,
a land
shut all this
contract
shit
that's
down.
sitting here that they're arguing supersedes all this stuff. If you want to testify and tell me why this lease agreement that you're talking about is legitimate, we can do that. Is that what you want to do first?
Why would I have to testify about a lease agreement that I'm agreed on the lease agreement with? I don't understand.
They're saying it's not a legitimate lease agreement.
Your Honor, I have a valid lease agreement. with
Okay,
Brian May.
I know what you want to argue about, but you want to testify and tell me why this is a valid lease agreement or not?
No.
They're on two different leases.
Mr. Bowser?
Well, Judge, if that's his position and that's the end of the proofs, I submit to the court that we are entitled to possession of that property, that Mr. Miller is a trespasser.
Not a trespasser.
Objection, Your Honor.
Mr. Miller, you're kind of getting yourself in a jam here. I've got nothing else here.
They probably own the land under it. I was like, I want my money back then. Plus interest. Cause I could have took that 144,000 and tripled it by now.
Yeah, I'm gonna take a brief recess off the monitor. I'm gonna get
The lawyer?
the pleadings
Yeah, he
actually
does
in
need to
order
come back.
Give me just a minute here. All right,
Okay, sure,
hold
Judge.
on.
Thank you.
All right.
Oh, now it's kind of HD.
Okay, we can go back on the record.
Look at
Mr.
his son though.
Bowser,
His son is
I
like
did
gotta
find some
be
orderly
40s, 50s.
fashion to the exhibits.
Still an alcoholic, drug
The
addict.
land
Like that's
contract
crazy.
That's been admitted. It's July 27th,
He should have done that
2005.
anyway instead of paying. True. True.
Is there language in here? Can you point me directly to it that says that the land can't be encumbered by purchaser? That being Brian May?
It
Is there
was
a place in there?
subparagraphs G and H, and I'll get that language here.
Okay. G and H.
Not
Yes.
recovering from a drug binge.
In paragraph G, 1, 2, 3, 4, fifth line, fourth line down, that the purchaser and any other occupant, remove and put out.
I'm sorry, which paragraph are you on? What,
On G, the small G,
Does he have a copy of that?
in section purchaser agrees to,
that would be in section 3. I'm sorry, Judge.
Oh,
I feel like they
three.
should give copies to
G.
Mr. Miller too, right?
G, okay. Should,
The third and fourth
I
line
read.
of that paragraph.
purchase seller. Conditions.
And also paragraph F, I said H, but it's really F.
Okay.
He don't even know his alphabet.
But G is the main one, Judge.
Okay.
Read it again for us. Is he smoking in there?
And as noted in the memorandum that I filed, Judge, because the land contract itself was never recorded, and the deeds were, the deeds take priority and the unrecorded interests really don't count. I mean, that's
Yeah.
a brief summary.
Okay. And so that's the second prong to this thing, basically.
So it doesn't
Yeah.
say anything about him
okay.
not being able to lease it.
Okay. And so the only ones that were recorded are actually the
Me either.
quick claim
It's
deed.
taking too long. Where's the
Yes,
contract?
And Michigan being a recording title state,
And we're talking about, I see, here's the issue I got with it. So the ones that were recorded, I do have the one that's kind of after the fact of this alleged lease agreement is a quick claim deed that's Brian May to the trustee dated August 14th, 2024. Is the other, what else has been recorded?
prior to that, the two deeds for Mr. May is corporation to his trust.
Look at how he's looking at.
Okay.
Look at how he's looking at his
Those are back,
lawyer.
if I remember right, I thought I saw 2005 or something.
He like, yo,
right?
why?
Yes, Judge.
You don't
Okay.
seem like you don't know what you're doing. Every time the lawyer's out, he like,
Yep, here it is. The one that goes from May Homes to the Jack D. May Trust. Is that right?
Yes,
Okay.
Judge.
Yep. And that's dated December 31st, 2005. Okay.
we about to lose.
And with that, Mr. Belzer so I understand the lease agreement that was submitted, is that, Mr. Miller, did you submit that to the court or was that given, did Mr. Belzer, did you submit that? The alleged lease agreement, the one's dated July 1st, 2024.
Riz, I think he was trying to get rid of some money real quick.
Ooh, that's from,
I had a copy. I don't know if we submitted it.
Mr. Miller, did you submit that from, it says landlord Brian May, property lease type to you? Did you give me that or did somebody else give me that?
He's on mute.
It's the lease agreement that you're arguing. You're muted.
Yes, Your Honor, I'm here.
Okay, was that your lease agreement that you submitted to the court or did it came in on August 30th, 2024? Is that from you? Or
I'm not for sure, Your Honor. I know the police station, the Flushing police got a copy of the Michigan residential lease agreement. I don't know if I brought that copy into you or not, Your Honor.
okay. It's got
If
some
it's a
blue
business,
highlights
and I
on
see
it.
my
I don't know
understand
who,
61.
highlighted it
still,
in blue. It's got
Money
some-
laundering? I think so, boy. He should have bought some land. He could have did a lot of things with the with the money he spent.
Well, I don't mind, Mr. Miller, if you don't want me to even look at this right now, it's not admitted, the lease agreement. You want me to consider having it admitted as an exhibit, I don't mind doing that, but
Yes, Your Honor.
if you want to do that, before it sounds like you didn't want to
I
even
thought
do
he
that,
had it
but
last time.
Do you want to try to get that admitted or not?
Yes, Your Honor.
Okay, Mr. Belzer, just for the sake of the record, I got my hand, it says Michigan residential lease agreements dated July 1st, 2024. It's from landlord Brian May to tenant Taji Miller, and this is one that has created all these issues as well. Mr. Miller, it's dated July 8th, 2024. Is that your signature on this?
My signature is on the lease, Your Honor.
Okay. And what
Oh,
about
man.
Brian May?
Brian May's signature is also on the lease, Your Honor.
And I'm kind of, maybe I'm throwing you off too, Mr. Bowser, but do you have a copy of that lease agreement?
I have a copy, but according to what I've been advised by Brian May, there was other language in that lease that's not on the copy I have.
Okay.
What other
Oh,
language could
we
it be?
got two different versions of it now. So, okay.
Is Brian
The one
May
that
a
I've got in my
credible
hand that was
witness
in the file, it's got
when
like
he's inebriated
39
half the
paragraphs.
time?
Maybe we can start out there. Maybe that's,
Yeah. Yes, that is correct, Judge. That's what I have.
okay. It is Brian May with you, you said? Is he gonna
Yes, Your Honor.
testify at all? We might as well, as long as he's here, we might as well, one of you. Mr. Miller, are you gonna testify at all or not?
Your Honor, I'm
Yeah.
a Michigan residential tenant. I don't think it's required by law for me to testify.
Okay, you don't have to then.
Okay.
Mr. Belzer, do you want
Brian
Brian
back there
May
in the
to
red shirt.
testify with regard to this, I guess this lease agreement? Or any agreement?
Well, Judge, I mean, if there's no other testimony except what we presented, I don't see the need for that.
Oh, that's true. I guess that's true. I'm kind of.
They don't
maybe I'm
want
going
Brian to talk.
overboard on it, I guess.
They don't trust Brian.
Yeah, I guess you're right. If it's not admitted, it's just not admitted. I guess I don't have a real lease agreement in front of me.
It is admitted.
It is admitted, Your Honor. You just admitted it.
No, I didn't. I didn't admit it yet. It has, no foundation's been laid. Nothing.
Your
No.
Honor, you asked
The
me did I
judge-
want to admit it, and I agreed to it.
Yeah,
on
so
record.
that's why I'm trying to go through proofs for you to get it admitted, and you said you didn't want it and you didn't want to testify, so we're kind of past that.
The judge is not on that
You just told me
brother's
you didn't
side.
want to testify, so. Mr. Belzer, let's go back to your complaint here. How has this been filed? Well, I guess, Mr. Belzer, if we want to, just want to give me a final argument, I'll review the documents that have been admitted and we'll go from there.
Judge, basically, Mr. Miller is there under no claim of right. He has no claim to
Missed
that
his chance to
property
bring up
be
the
in that
contract.
property, and we just ask for an order of possession of that.
You doing a lot of
property and
guessing.
evict Mr. Miller.
Okay. Mr. Miller, anything else you want to tell me?
Yes, Your Honor.
Okay,
Your Honor, I would like to ask the court if I could move to dismiss this matter on a basis I was never provided a notice to quit. As a result, I am entitled to due process, which requires a proper notice to quit be served, and without proper notice, the court lacks jurisdiction and the case should be dismissed.
okay. Mr. Belzer, why should he have a notice to quit? Or maybe he shouldn't.
Well, he should, Judge. I mean, I think the law is real clear. I mean, he has no claim of right, and my review of the law does not require that he be given a notice to quit. And
Yeah. Yeah, but I did get a chance to review all the documents. I'll come on just a minute. Let me make a decision. I'll come right back on. Okay,
thank you, Judge.
all right, right.
It's looking bad for Mr. Miller, which is crazy because he read books about litigation.
Okay, let's go back on the record again. Jack D. May revocable trust versus Taji.
They didn't even get Mr. Miller's
Had a chance
lease
to review
agreement in
the,
there, so he basically just
exhibits
judging
that
it
have been
based off of
admitted
their
in this
land
matter.
contract.
As far as my notes with regard to testimony, I do find that I'm going to go through documents first. There was admitted Exhibit 1, land contract dated July 27th, 2005. That land contract was between May Homes, and I'm abbreviating names, but May Homes as seller, and Brian May as purchaser. There is some language in that land contract that says this property cannot be encumbered by the purchaser, and the purchaser being Brian May. One
Yeah,
portion in particular
that's
says
what I would have
in,
been on, Nay.
it's a paragraph, purchaser agrees, paragraph 2 of the land contract. And for the record's sake, this has not been recorded, which is another element in this, but was not recorded. But it does state under paragraph 2, subparagraph D, purchaser agrees to keep and maintain the land and the buildings in as good a condition as they are at the date hereof, and not to commit waste, remove, demolish, or improve thereon, or otherwise diminish the value of seller's security without written consent of the seller. Throughout this contract, if there's any changes in the state of the property that diminishes the value of the seller's security, that has to be in writing. There's nothing in writing that's been submitted today that there was written consent by the seller to somehow diminish the value, given the what Mr. Miller has testified to, this excessively long lease agreement that he's referred to, which has not been admitted, but he's stated that there was a lease agreement.
Mr. Miller gonna tweet.
It's a long-term lease agreement for, I think it was 60 years. Yeah, July 1st, 2024 through allegedly ending July 1st, 2085 with monthly installments of $1,000. It significantly diminishes the value or the
That's life.
seller's security in this property. There are other provisions in this land contract that state very
He
clearly
did have a
that
receipt. He
property
had a
cannot be
receipt,
encumbered
but he
by the
paid cash. It was like
purchaser.
one of them receipts you just write up.
Again, if you have nothing in writing that says that the seller, and again, that being at this point on the land contract, May Homes gave written consent to have this property encumbered. Just thus reducing seller's security in that property. Should be noted, there's also a quit claim deed that was recorded. It was quit claim deed on this same property from May Homes Realty to the Jack D. Mays Trust. That was dated December 31st, 2005. I've heard nothing as far as testimony that disputes that ought not to have been able to have happened. That was recorded. I'm sorry, that was not recorded, but that was going into the trust. And then there is the actual quit claim deed dated February 10th, 2015, that quit claimed May Homes interest in this same property on Pine Needle Trail that's at issue for today. Quit claimed it to the Jack D. May Trust. On that date, it was recorded February 13th, 2015. That by itself says the recording, since it was recorded, it's the Jack D. May Revocable Trust that is the owner of that property at that point. I've heard nothing to dispute that, other than we've got what Mr. Miller purports is this alleged residential lease agreement. Heard no testimony. Mr. Miller refused to give any testimony with regard to that lease agreement. He wanted to argue that he did not receive a notice to quit, but given all of the documents, there was no lease agreement that was enforceable on this property. Brian May, in fact, also the Exhibit 4 quit claimed his interest in this property. Now, it was after the fact. The purported lease agreement is dated July 8th, 2024, but Brian May did, whatever reason at that point, quit claimed any interest he may or may not have
Bro,
to
just
the May
yapping.
Trust on August 14th, 2024 on that document as well. But that was after the fact. If the lease stands, I find that there was no enforceable lease at this time. That property could not be encumbered by Brian May. And in fact, given the testimony I've heard as well, Brian May was in default on this land contract that was not recorded.
You think he might win it?
No action was taken from the being the familial relationship between Brian May and Jack May and the revocable trust that was established. No action was taken because, quite frankly, this property had already been deeded over, quit claimed over to the trust on February 13th, 2015. That's the only document that's been recorded. The credibility of that document stands beyond everything else that I've heard. And therefore, there's no lease agreement in its entirety.
Taji's
And
smiling, but I think he
Mr.
losing.
Taji Miller is a holdover person on this property, not even a tenant, quite frankly, based upon all of the documentations and all the testimony that I did hear. Given the fact, though, that Mr. Miller has been on that property for a period of time, I will give him is he on that property now still?
Hell yeah.
I'll give him the statutory 10-day period to move.
10 days.
We'll prepare the appropriate orders.
Okay.
10
Okay, very good.
days.
Thank you, Judge.
You're welcome. Good luck to everybody. Okay.
Thank you.
All right, you're welcome. Good luck, Mr. Miller.
I would have been sick.
Oh.
They didn't say nothing about his money. I would have started tweaking. Hey, hold on, Your Honor. What about my $140,000 I gave Brian? Like, where that at? Where that at? Your Honor? Like, what? I would whole court call what is doing crazy. Taji in there smiling. Nah, Taji. I need you to say something, man. Fight back. Smiling and muted. Like, come on, man. Come on, man.